I'd just like to say good afternoon and welcome to all of you, and thank you very much for coming and joining this, which is the third webinar in our series, which Mills & Reeve is running this week, focusing on issues relating to owner-managed businesses and family-owned businesses, looking at some of the subjects which affect them, which we see on our own practice and which we know will be of interest to all of you. Just before we start, I've got a few housekeeping points to mention, if I may. First of all, if there's any tremolo in my voice, it's not through nerves, it's through the fact that the room is so cold where I'm speaking to you from that it might make me quiver, but and I'm sure it's the same where you are, so it's a pretty cold day for doing this, but thank you for joining, and hopefully it will be interesting enough to keep you warm and engaged as we go through the topics. The session is being recorded. If you have any questions that you'd like to ask any of us during the session, please put them in the Q&A function. We'll be able to see those, but they're anonymous, so other attendees won't be able to see your question, but we will, and we'll keep an eye on that, and we'll try to respond to them as we go along. We do have a little bit of time available at the end, if that is useful, to enable us just to address some of those Q&A. Alternatively, obviously, please do feel free to contact any of the three of us following this session, and our details will be on the screen shortly, and you will be able to get in touch with us directly, and then we'd be really happy to respond to any queries or thoughts that you have. Once we're underway, it might be useful for you to have Zoom in gallery view, I think, because there aren't going to be any other slides after this one. It's just going to be a conversation between the three of us, so you might find that gallery view is the best one to use. Just to introduce ourselves, so my name's James Hunter. I'm a partner in the firm here, and I lead our national corporate practice. I've got nearly 30 years experience advising family-owned and owner-managed businesses, and actually I sit as well as a non-executive director on a family-owned business. So I'm a non-family, non-executive director on the board of that company. Deborah Clark, one of my private client partners, who started out actually working with KPMG before moving to work with us, and specialises in really assisting her clients with estate planning and helping to protect and control the succession of family wealth, and in particular doing a lot of work around family investment companies as well as family charters and sort of related issues. And then my partner, Alex Kenworthy, who's the only one amongst the three of us, I think, who could deliver this entire session in French if you wanted him to do. Fully bilingual. Please don't, Alex, but he could if he wanted. Alex is a corporate partner as well, also very experienced advising family-owned and owner-managed businesses, and particularly focusing around sort of structuring issues and corporate governance. The key thing really in the title was to try and help us think about where on the spectrum one really wants to try and place the business, somewhere we think in between the sort of autocracy of the Corleones and the chaos of the Falters, and somewhere in between we think is the right place for your business to be. So we're going to look at three main areas really. The first one is going to be around the interaction between owners and the management in a business. Then we'll look at a little bit at family charters and how they can be used. And then finally, we'll look at sort of issues around transfer and succession of ownership. And just really setting a bit of context, I mean, I think it's useful for us to keep in mind that kind of classic Venn diagram, which I'm sure many of you will have seen and be familiar with, which looks at the sort of interlocking circles between family, between ownership, and between a business. And it's always useful, I think, in any dealings that you have to keep that in mind and to think about where individuals sit in that Venn diagram. So you might have family who are not owners and don't work in the business, but of course you might have family who are also owners, and some of them might also work in the business. And you might, of course, have people working in the business who are not family, but might be owners or might not. And so with all of those interlocking loops, you have a number of competing sort of interests and potentially competing priorities. And so, Alex, I mean, turning first of all to you, just thinking about that from a company law perspective, perhaps initially, I mean, what sorts of tensions do you think can arise because of those sort of different perspectives?
Yeah, I think a lot of it's as you say, it's about the interaction between family and non-family, if you like, and the interaction between everybody. Quite often you'll see families, the business has been in the family for generations, and they've very much got their eye on an aspiration for succession, so they're looking to pass it down the family, and not particularly looking at an exit or a realization. If you've got somebody in the business who's maybe brought in because of their experience or their particular expertise, because that isn't available within the family dynamic itself to really push the business forwards, often the best people will come at a price, and they'll say, well, actually what I'd like is some skin in the game, and they're hired to really drive the business forward, and they may look to take or to at least ask for equity in the business. But again, as we said, it might be difficult for that equity to realize, because often it does come at a time when you exit the business, and the family might not want to do that. They'll want to pass it on. So you're often left looking at other forms of incentivization, if you like, which, if they're remuneration based or performance based, they don't always carry the same tax advantages. So what you often see from a company perspective is often sort of splitting the share capital up, so you can get different categories of shares, and they carry different rights. And so that allows you automatically to start to cater for owners and non-owners. But the minute you start to give equity away, there comes an element of risk to make sure you can get the shares back if the relationship breaks down, and sadly it often does. So what you do get are these sort of lever provisions, which basically it's provisions which are attached to the shares, which say that the company can get those shares back if and when those holders leave the business. Now, and the price which they will receive for that will depend on the circumstances on which they leave. So they could be a bad leaver if it's a sort of they leave of their own volition, or if it's a gross misconduct situation, for example, or they could, if they're a good leaver, so typically retirement, which would allow for an exit in its own way, or death or incapacity or unfair dismissal, something like that, then they can realize sort of a market value. So it gives them an exit route.
Yeah. And I guess, as with all of these things, there kind of needs to be some clear thinking, doesn't there, and clear communication between the sort of family interests, perhaps, or the successional interests in the business and those management, so that really they both need to understand where each other are coming from. And also, I think there's sometimes a rush to issue equity when there can be some other ways of rewarding people, as I think you indicated, that might not involve the complexities around equity. I guess as a thought as well, is there, Alex, around positions on the board and how that might work?
Typically other tensions arise. You were talking about tensions. It's about the level of involvement and influence. Typically, if somebody has got equity, they'll have one eye on that, and they'll say, well, look, I want to make sure I can drive that equity value forward, and therefore will look for a degree of influence. And then you get the personalities involved can always be quite tricky to manage that. So typically, you have to understand, the risks of putting somebody on the board. They might seek, veto rights if there are shareholders as well on certain decisions in the shareholders agreement as well. Typically, again, it depends on the bargaining strengths and the characters involved. Quite often you'll get a management who will come in with the basis of, well, if I don't ask, I don't get. So it might, it's really about finding a happy medium between giving them a degree of influence and making sure that the control is retained.
Yeah. And Deborah, I mean, other kind of tensions that can arise around that Venn diagram, and I suppose I'm thinking around, relationships with people as employees, perhaps some stuff around, the sort of trying to convey the culture and the priorities of the owners. Do you want to just talk a little bit about that?
Sure. You're absolutely right. So you have, obviously, with a family, even family members who perhaps aren't directly involved as employed, if the family, if the business has been the wealth generator, it's the sort of key part of the family, then even those that, whether they work in the business or don't work in the business, may still have a relationship with the business, even if it's not formalized, by employment or by shareholding. There might be a generation that have an expectation that they will receive the shares from mum and dad when succession takes place, or they may be be a beneficiary of a trust that's sitting there holding shares. So you have all these competing sort of interests really as to those that perhaps have expectations in connection with the business, those that are actually working in it, and those that are shareholders. So they're interested, it's a key asset for them, but they're not directly involved on it on a day-to-day basis. And I think one thing I've learned with experience is that every situation is very different, and the dynamics is always different, whether you've got an owner-managed business, but you've got 2 or 3 owners, but their families are sort of intrinsically linked with the business. It gives you one set of sort of dynamics. A family business that's been in the family for generations will have a completely different set of sort of factors. But there is always, I think a real importance to kind of understand what is relevant to the family, what is their relationship with the company, how important is it to them, is it going to be retained, is expectation that it will be retained in the family for generations, or is it actually just first generation, but it's been the wealth generator and an expectation of an exit at some point. And understanding what the family's relationship is, what they think about it, is really important to start to unpick what the issues are likely to be. And obviously the relationship with the company is directly relevant to all those that aren't in the family, and whether they're board members or employees generally, as to how those two groups interact with each other. Sort of understanding that, because it can create lots of tensions, and the tensions often come at a period of change. Maybe being stereotypical, but if it was typically the father that's started the business with his business partner, but then hits ill health, and then is the widow or maybe or wife sort of involved, or is the children looking to think, well, how do we protect the family's interest in the business? So it is it's fraught with tension, but typically tensions come as a result of some change, ill health, death, or some transition in the business, new people coming in, taking equity. That can be often a period where sort of these tensions can come to the fore.
And of course, I mean, and sometimes what you see, and we saw this, I think, a little bit in COVID and in the 08-09 kind of financial crisis as well, is when times are really tough for the business, then some of that kind of succession planning that kind of by instinct one tends to want to do in a quite an orderly, structured, linear way sometimes gets interrupted, because you've just got to get all hands on pump and save the business or cope with whatever the environment is. And then of course what that does or can do is stack up some of those sort of other issues, can't it? And then they just become, so you might have the older generation are sort of hanging on while that situation arises, but the younger generation is still impatient. And it's a bit beyond the scope of this talk, but another interesting area that we might talk on in some of the other sessions this week is addressing that situation in a family where you have somebody who's keen as mustard and very much involved and the obvious successor to the business, with other members of the family just doing things that are completely different, and how you reconcile that in terms of balancing the family's wealth is quite an interesting topic, but not one we can get onto here. But I'm going to just move us on to the sort of second main area that we were going to look at, which is actually linked and stays with you for now, Debs, which is around family charters. So I know this is something that you've worked on a lot with clients, and could you just talk to us a bit about what those are, what they look like, and how they can be useful?
Yeah, so a family charter is it can be different. Again, it sort of can be different depending on what it's covering. But in relation to a family business, a family charter is in a sense a sort of document that records the consensus of the family and its relationship with the business. So it's looking at what does this business mean to the family, what's the family's wants for the business, what's its intention, is it a multi-generational business, is it what do the family see as happening to the business, what direction is it going in, what would they what activities do they want to see happen and not happen, what its relationship may be with the community and its employees and workforce, and so it tries to sort of capture what the relationship is, what the goals of the family are for the business, and it also can very helpfully set out what the relationship with the business is for the family members. So, is there an expectation of being able to get a job? Is there, how are you going to interact with the board? Is there an expectation that there'll be family representation on the board? How do you manage disputes? How do you sort of manage that relationship within the family and the board and the company, which is generally represented by the board, but also with the family and each other? Like you mentioned earlier, some might be employed in the company, some might not. Who's going to be the next MD? How does the family sort of resolve those kind of issues? Who's going to be the family representative? So it's a document that quite often actually isn't even legally binding. So that's one of the sort of key comparisons with the shareholders agreement. And it's a document that doesn't, it encompasses more than just shareholders, more than people that have a direct relationship. So it might include, beneficiaries of a family trust that owns shares, people that maybe have an expectation of receiving shares in the future, as well as those that are shareholders and are involved in it. So it's a broader document than a shareholders agreement, which is a much more legally binding document between those that have shares in the company. But it is very useful in terms of trying to sort of look ahead and see where those tensions might be. How are you going to resolve them? So it is a very helpful document, I think, and can help both the family understand and have clarity about what the relationship with the business, but also, I think, quite crucially, it helps the board of the company understand where the family is coming from as well.
And so presumably something which you keep under review and is evolving.
Yeah, no, absolutely. It's very much a living document. It is one that you want to keep looking at, sort of perhaps at family meetings every few years, just to make sure if it's still relevant.
No, that's really helpful, and certainly something I've seen used really successfully in some businesses, and as you say, I think part of the success, and people might think it's odd us saying this, but I mean, part of the success of them is that they're not legally binding. These are statements of principles and broad objectives and aims, which can then just be the reference point really for some decision making.
Absolutely. And I actually would also say that one of the key benefits can come from just the fact that you put one in place, because so much of it is about communication. And actually it's not about a founder or senior members of the family just dictating what's going to happen. It's about involving everybody, all the stakeholders in it if you can, having those conversations is actually sometimes where the most value is, and the document at the end is just the record of it, but the real value can come from making them have those conversations.
That's really interesting, thank you. And so as the snow does begin to fall outside my window, Alex, and it gets colder, come back to some more legally stringent or legally binding provisions, and starting to think a bit around transfer of ownership and succession, because this is an issue that inevitably crops up in a sense, and also is an area that's relevant not just to family-owned companies but owner-managed businesses as well. So just thinking about both of those really, and talking about ownership of shares, what are the kind of strategies that you see being used to, if you like, control the ownership of the company and the destination of shareholdings?
I think the point we were just talking about is a really good one about, quite often the provisions in articles of association and shareholders agreements can be quite legalistic because they are binding, and they can seem a bit overbearing sometimes. And I think that's why it's helpful to have something like a family charter document, which sets out the basic principles which everybody understands and buys into, which are then replicated, if you like, within the more formal documentation. I think on transfers, it basically falls into two categories. You've got the provisions which apply when somebody wants to leave the business, when they want to exit the business, and the other scenario is where someone just wants to move their shares for other reasons, be it tax planning or something like that. So keeping keeping it within the family circle, if you like, but having that degree of autonomy to move your shares around without having to get the consent of everybody else. So I think if you've got those parameters understood, then the legal stuff can follow in more detail. But essentially on an exit, you normally have sort of detailed transfer provisions in your articles of associations, or sometimes replicated or copied into the shareholders agreement. It means that if someone wants to transfer their shares to secure an exit, then they can be purchased, they can be offered to the existing shareholders pro rata, so that everybody can maintain their existing shareholdings. But it's important to understand that family members might not want to buy anymore, they might not want to spend their money in that way, or they might not be able to. So typically what you have there is an offer round, so spare shares can be offered around. So there is a market, if you like, internally. Where you often find a block in this sort of company is on them leaving the corporate group. So they could, for example, be bought back by the company by way of share buyback or own share purchase. That's a possibility if the legal tests are satisfied. But typically what you would always have is a block on them being offered to a third party, unless there are very strict controls by the directors to allow that. But trying to provide a market within the company's existing base of shareholders, or alternatively offering them to management. So typically we're talking about class rights earlier. If the families hold a particular class of shares, they can be offered around there. If there's some left over, they can then be offered to management, particularly on a second round. So there are all sorts of mechanisms.
And presumably, and sorry, Alex, and presumably, if you've got a strategy for succession, then permitting transfers within family, sometimes within bloodline. We do sometimes see that quite narrowly defined definition of what would be a permitted transfer versus a much broader construct, which would include transfers to family, married partners, to their children and offspring, and so on. So I think an issue I think it's worth just sharing quickly, in my own experience, is that those definitions actually can be really important to talk through very carefully. And again, one has to be very open and have a holistic view of all of these issues, which I know is something we all work really hard at here, isn't it? To make sure you have those conversations and you can think about it in a holistic way as to, where to place them. Someone's asked a question, actually. I'm just going to bring in a question that we had, because it's quite interesting on this sort of topic. It probably was prompted a bit about your discussion on the family charters, Deborah, but I think the question is that, in a sense, a lot of this stuff is the elephant in the room, particularly with family businesses, and the challenge can often be how you broach these. And how, I just wondered whether, in your experience, you've got any thoughts on that, really, as to how to start these conversations in the first place.
I typically start it with probably with some war stories of where I've seen things perhaps not go right. I mean, often there is a trigger. Often there is something that maybe happens, or there's a foresight of potential issue with a member of the family, a tension that is looming, and it sort of triggers the broader discussion. So it's I mean, I get to raise these sorts of unpleasant topics all the time in my line of work. Maybe I get a bit used to it, of raising sensitive things, but you just have to, really. It's a bit like anything. And you could always sort of talk about it in a well, it probably would never happen to you, but what ifs.
This is what I've seen, and I guess it's something that a good non-executive or chairman or critical friend is valuable here, isn't it? Those are the sorts of topics. I mean, it's the benefit of not being in the family and being able to say, look, this is coming down the line, or perhaps driven even by tax or fiscal changes or something else that's just saying, look, this is not sensible any longer. We need to look at doing it differently. So yeah,
absolutely.
I think that's a good point, James. Is we talk about living and breathing documents. These things do need to be kept under review, because things change, not least law, tax rules, and of course family dynamics. We've already talked about it. So yeah, absolutely.
Yeah. And what about sort of pre-nups and post-nups
Yeah, well, I mean, a key issue for all families is protecting the family wealth, and and I mean, Alex has talked about share transfers, and do you or not allow spouses? And there is a tension there between tax planning sometimes and protecting family wealth, because it's often quite attractive to look at sort of how are you using your spouse's allowances? Should they have a few shares so they can have the dividends, and that's tax efficient. But fundamentally, protecting wealth is I think becoming more important than perhaps clients think more about that at the cost of some of those tax planning, because keeping control and a tight control over who is a shareholder, I think, is actually really important. So limiting share transfers to just family members, and that is, as you mentioned, James, typically bloodline, that is what we see probably most these days. But also, people often talk about, well, what more can we do to protect? We can put things in the articles, but how, and in a shareholders agreement, but how do we go even further? And the use of premarital agreements, pre or post, you can do it before the marriage or after, but having an agreement as a married couple about how you will deal with assets on a separation is really important. They are, I'm not a family lawyer, so but they are generally going to be upheld by the court if they are sensible and fairly done, and you follow a process of not making sure that they were entered into appropriately, so you don't produce a draft on the morning of the wedding, obvious things like that. But they are really useful, and we do probably more in the context of a family investment company type structure than a trading company. But having said that, I have seen it used in trading companies as well. Is actually put a requirement in the articles for individuals to have a premarital agreement or postmarital agreement. You can't force somebody to do that, but what you can do is look about and have a view about what happens to their shares if they don't do it. So you can't make them sign one, but you can control the shares, because so it is something. So a typical thing might be in a shareholders agreement or a family charter, you just simply express an expectation in the family that if you get married, you will sign up an agreement so that you can protect the family assets, and you can make sure that the shares in the family company are they will be taken into account, because you can't avoid that. It's an asset available to them, but they're not going to become a shareholder, that those shares will be ring-fenced and protected as far as possible. Although you will need to find funds somewhere to meet their needs. That's sort of inevitable. So you can, light touch is just to say there's an expectation. Sort of more stronger is actually to make it a requirement in the articles, and then taking effectively your only tool is to take shares off them through some compulsory sort of transfer provision if they don't comply with the requirement.
Yeah, no, thank you very much. That's really fascinating. And I think you touched upon trusts as being another mechanism to sort of control ownership, legal ownership versus, beneficial interest. And my one remaining war story, because we've got very few seconds left, was just to caution against transferring shares to children, because that can then cause quite a lot of as the legal owner, I mean, we've had some problems with companies having very young people registered as the owners of the shares, which can then be a challenge. When it comes to trying to do
put them in
later.
the names of minors.
Not great news from our perspective. But look, we've already run out of time. Not surprising, it's a topic that covers epochs, and we've only had 30 minutes. But it's I think one of the really enjoyable aspects of this kind of area of work is that it takes you out of the strict legal and into a much more holistic viewpoint on what is in the best interests of certainly family-owned companies, but also owner-managed. As I say, there are crossovers with many of these issues. Thank you very much, and again, for everybody who has joined this. I just remind you that we're midway through the week, and that we're doing these all week. We're here all week, and there are at least another 2 of these sessions, I think, in plan. If you want any more detail, please reach out to any of the 3 of us, or just to your normal contact at Mills and Reeve, and we'll be really glad to hear from you. But that's the end of this session. So thank you very much, and enjoy the rest of your day. Thank you.
Thank you.
Thank you.